Good afternoon. I'm Sheriff Nate Sickler, and welcome to the Jackson County Sheriff's Office podcast. We're doing our second episode today, and we are going to be talking about changes to Measure 110. And to do so, I've invited two very important guests and pieces of our criminal justice system. We have our DA, Beth Heckert, here, and we have Kiki Parker-Rose, who is our Community Justice Director, who are both going to play really significant roles in how we implement the changes to Measure 110 and how we use our resources locally to hopefully make a better Jackson County. So welcome to the show today.
Thanks. Thanks for inviting us.
Yeah. Why don't you both, Kiki, why don't you start and tell us about, your job, what you do, and what community justice kind of does, a quick overview.
Sure. So community justice is made up of three departments in Jackson County. We have juvenile services, which is our detention, probation, intake, and diversion. We also have a residential treatment program. Transition center, where we house folks moving from custody into a transition program, and then we have transitional housing, a Bureau of Prisons contract. We dispatch our work crews from the transition center, and we have two on-site residential programs. And then we have adult services. And so adult services is adult parole and probation, so we're responsible for the care and supervision of adults on supervision within Jackson County, which includes probation, parole, post-prison supervision, compact cases, and conditional discharges. So we oversee a population of approximately 2,400 youth and adults within our community.
Yeah, pretty busy. And how long have you been in the public safety sector?
This is my 33rd year.
Awesome. That's a long time.
Yes, it is.
Yeah. So a wealth of knowledge. And Beth, everyone might know what a DA does, but briefly just talk about like your role.
Sure. So Jackson County District Attorney's Office prosecutes all of the crimes that occur, all the state crimes that occur in Jackson County. So we're a pretty busy office. We handle a lot of cases. We have a staff of 54 people. 22 of those are lawyers. So when we're fully staffed, we're the largest law firm here in Jackson County.
Yeah. And very busy.
We are very busy.
And we might talk into numbers, but I always like to, when I became the sheriff, it was frequently we were blamed for letting people out of jail. As we've gone through the years of trying to explain the space needs of our county and all those things, we've done a good job of deflecting, I guess, the blame. And sometimes the DAs and the courts get blamed now. So I apologize for that. But I don't think people realize the busyness of our criminal justice system here, and that, like, for pound, we're doing a lot of work compared to other counties, especially bigger counties, which might have, double the population or sometimes even 3 times the population with like Washington County. And our DA's office is filing charges similar to their offices with just a fraction of the resources. Then we got to supervise high-risk offenders here, which is, like another piece of the criminal justice system, which is, I think, a testament to the hard work of everybody. But
absolutely
interesting how busy it is. I don't think people realize it unless you're in the system. Mm-hmm. And even those that are in it, I think, get inoculated to the high-speed system. Right. That's kind of what I see anyway. Yeah,
we've always had high caseloads, and so we're just used to it.
Yeah.
When we talk to other counties and then they ask us, well, how do you do that? We're like, well, what do you have? What do you mean you don't have the same amount that we do?
Yeah.
So I think you do definitely get kind of inoculated to it.
Yeah. And so I think today what's interesting is we have the talk about the changes to 110 what that House Bill 4002 brought. And it was just signed, I think, like 3 weeks ago by the governor, or roughly 3 weeks ago. So passed in the short session. But we have 3 components of how this system will work. Obviously, we don't have the judges here to talk about that piece, but I think we have the sheriff's office, and then, of course, our local PDs will make arrests. Those charges potentially could be reviewed by the DA's office if it goes that route instead of deflection. Then there's the decision to charge and whatnot. And then, of course, if they're convicted, they would go to your office. So we kind of have a pretty good representation of how things might look with the changes. So I think the first thing is to talk about is let's talk about the changes themselves, like with regards to where we were during Measure 110 and then now with the new legislation and when it'll go into effect, which is September for some, but some things are effective immediately upon the governor's signature. So those things could be enforced now. Let's just talk about those changes overall. I think that's important. I think Beth's a great person to talk about some of those things with the charges. But immediately upon the bill being signed by the governor, we can kind of go back to the way things were a couple of years ago with regards to drug dealing. Is that accurate?
Yeah, definitely. So it was a legislative fix, but it was a court opinion that changed how we could charge people who had delivered controlled substances. So before that court case came down, and Hubble is what it's often called. So before that case came down, if you had a large quantity of controlled substances, pounds or substantial quantity, way more than you would have for your own personal use, and the police arrested you, we could prove that was a delivery, that was what your intention was to deliver it. So that has a lot more stiffer penalties for people, as it should. And when that court case came down, they said, no, you needed some additional evidence to prove they really were going to deliver it. Either they had to admit that's what they were about to do, or you had to find other records that would show that was what they were about to do. So that really limited our delivery of controlled substance charges that we could charge. Unless you caught someone in the act of actually transferring it over to someone,
Sure.
It was very difficult to prove. And so then we had to charge attempted delivery of controlled substance when we would find someone with a huge quantity of drugs and no other evidence. So one of the great things that came out of House Bill 4002 is they fixed that legislatively. So the court opinion. So now it's you can have a possession with intent to transfer. And if we can prove that, so it kind of put us back to square one with our deliveries of how we were doing it, let's say 5 years ago.
Yeah. Good. And so I think there was also some enhancements for like locations with regards to that. Is that so? Like I know treatment centers, there's an enhancement if somebody's dealing drugs or distribution of narcotics around those facilities, and then there's parks
and shelters.
So that's new with House Bill 4002.
Yeah.
So that's a good thing, and I think I hear things in the community. I don't know what you may have heard from some about, well, this isn't strong enough, this 4002, and, this is a weak attempt at trying to fix what it was before. But I think there's a lot of things that are good in this bill, and this isn't
definitely this is a positive.
Distribution is a big piece of that, and those are really the people that we're probably looking at who are going to be doing more jail time if they're caught. And they're the ones that are bringing in the fentanyl and the poisons to our community. And so I like having that more significant penalties and chances for enforcement in those other locations. So I think that's good.
Yeah, definitely. And especially I think the parks piece will be the one that we'll see it. That's really where a lot of people in our community see this themselves. So
Sure.
They might stop going to the parks because they're seeing drug activity just out in the open and no consequence. So it really did add a good enhancement if that is occurring within it's 30 feet of a public park. So that's
pretty close,
pretty good.
10 yards. I mean, like a first down in football, or, a third of the way to, or halfway to a base path or something. Anyway, so it's not bad.
I think that it's also good that it did include the transitional housing portion, because a lot of the folks that are utilizing those types of housing have addiction problems,
Sure.
or are working to stay sober. And if you just walk outside and get into a car and there's somebody that has drug access, then that prohibits them from being successful.
Yeah.
So I'm glad that they did include transitional housing or
Shelters is what they call it. But yes, it has a pretty broad definition.
Yeah.
So like, for instance, like the urban camp that Rogue Retreat runs in town, that would constitute.
count.
So somebody was bringing drugs into that location where people were trying to, get clean and get a hand up, so to speak, and change their lifestyle. Somebody got caught with a significant amount of drugs in that location and maybe some other things that pointed to delivery. They could be convicted of that, delivery of a controlled substance. Yeah.
Yep.
So I think that's really important. And I think when, people talked about, like, there was this ballot measure or initiative petition, citizen initiated petition, that was also kind of lined up to go, which has been withdrawn since. Had a few more stronger penalties to it, but I don't think people realize that nothing would have got done with that bill until maybe, July, September, October of 25. So we would be having to continue to operate even if that had a little more teeth, we would have been doing nothing until probably another year and 4 or 5 months.
Mm-hmm. That's true. And these parts of the bill went into effect right away.
Yeah.
They had an emergency clause.
Yeah. And then so we talk about, so we got the unclassified misdemeanor. Now, people talk about that like, well, is that less than an A? Is it more than an A? During Measure 110, we used E-violations, right? And so those don't fall under the purview of the district attorney's office, right?
No.
Purview. And they just go under circuit court.
Yeah, and they're like a traffic ticket is what they were. So
they were E-violations. Yeah, so
they were less than a traffic ticket, actually.
Yeah, because they were like the seatbelt is a D violation, and these were less than a seatbelt. So you could essentially say that it would be more egregious to drive 3 miles over the speed limit than to have fentanyl. Kind of a odd thing. It wasn't really successful at motivating people into treatment, I suppose.
That's what we saw.
Yeah.
People weren't going into treatment. We didn't see the cases, so we weren't talking directly to individuals, but the numbers that we saw statewide and in our own county of people trying to get into treatment, it didn't work the way that they originally thought it would. Yeah,
I think the engagement rate was less than 1% or 0.1% or something like that. It was really minimal.
Yeah, it was very minimal. The other piece about that is that when you have the e-violation, there's no extra motivation for that treatment, but then they continue to engage in behaviors such as I think we saw maybe a spike in shoplifting and some of those types of cases. Maybe not directly related, but by the time there was any type of intervention, we're already talking about crime categories of, A, B, or C misdemeanors or A, B, or C felonies where we didn't have the ability to intervene in that addiction earlier. So I think people feel like this isn't harsh enough, but at least it gives us some tools that we can continue to move forward, especially when folks come over to community justice and have the ability to try to intervene in that criminality or addiction if they're interrelated.
Yeah. So speaking of penalties, so before Measure 110, if somebody got arrested and you decided to file charges, your office decided to file charges on an A misdemeanor possession case. So let's say it was either methamphetamine, cocaine, heroin, fentanyl, anything like that met that threshold of an A misdemeanor. What would happen to them generally?
The penalty could be up to a year in the county jail because it was a misdemeanor, but that didn't generally happen. So you would be placed on 18-month supervised probation, treatment required, a supervised probation required. So you'd have some conditions that you had to do, and then a package of things like you could be drug tested. You could have to do UAs. You'd have some other things like that you would be required to do in order to successfully complete probation.
Now, when judges make the determination finally at the court proceeding of whatever it is, they plead guilty or they're convicted, the judges, do they use a sentencing matrix for A misdemeanors?
No, there is no guidelines. We have just kind of set ones within our community that we would make maybe a standard recommendation of 10 days in jail, for example, for your first offense.
Sure, 10 days. But
that was just a standardized within your own community. Different communities might have different standards.
Okay. And so up to a year before, now it can be up to, under the new House bill, what can it be?
6 months.
6 months.
6 months, 180 days.
And now is that all up to the judge themselves, or are there things that can be done? Yeah, there's kind of the way the legislature kind of explained it basically is you kind of have a couple of different options. So if you come into court, you've been cited by a police officer, our office has filed it, you're told to go to court on a certain date, and you show up into court. The way that it will work come September, so this is the part of the law that doesn't take effect until September 1st, is when you come into court, if the person wanted to plead guilty and says they are not interested in treatment, at that point the judge could sentence them to 180 days in jail. If they came in and said, I'm interested in treatment, then they would first be offered a conditional discharge, which is a tool that we've had for a long time. And then if they were able to successfully complete the conditional discharge, then they would get that off of their record. So they plead guilty, but it's not a conviction until they get revoked from it. So that's a good thing for the offender. Yeah.
If they get revoked from a conditional discharge, so at that first stage of conditional discharge, the judge can't give them a jail time.
Yep.
If they get revoked from the conditional discharge, now they could get some sanction units, and the court still can't give them jail sentences, but community justice would have the ability to give them some sanction units if they were just having a small issue or whatever.
Yeah.
You know, they quit checking in. They could give them a couple of days, or they could give them another type of sanction. They wouldn't have to be jail.
Sure.
And then in probation violations, they can be given, now that they have a conviction, you could have probation violations filed, and they could get sanctions for that as well. The court could give them some jail time
Sure.
at that point. So it's still definitely set up to try to really encourage people to get into treatment and to use jail as really a last alternative.
But the jail can be there in the event of all the other options aren't working.
Yep.
Then they can use jail still. Now, before 110 and before the law changed, because it used to be, we can talk about that there was felony charges for drugs, right?
Right.
But post that, what would you say the average time was that somebody spent in jail on your experience for a drug charge, if that's all that it was? So there's no other crimes attached to it. It was just a PCS, possession of a controlled substance charge. They're convicted in court. Just so we have reference of what a year in jail means by under the law, what 180 days means under the law, and then what's reality.
Right. So I think in our county, even when it was a felony and then it became a misdemeanor, we still kind of stayed with that 10 days. So if you're initially, you got between 0 and 10 days for it when you first got convicted. Now you could get probation violations and you could have some sanctions happen then. And I really don't have a sense of what the average would be for someone who maybe had a couple probation violations. But my guess would be most people, even if they ended up getting revoked from probation, likely didn't serve more than 60.
Yeah.
And that would really actually be a pretty long time. But I don't know, do you have any better idea what the numbers might be?
What I can tell you is the longest you could have revoked somebody was for 60 days, just based on how the sentencing
So
guidelines.
under justice.
Under the felony version.
Oh, felony version. Okay.
Yeah. We could sanction up to 30 days, and then after we utilized all of our sanction units, then we could ask for revocation, and the max would have been 60. The max we could have recommended would have been 60 days, just based on the sanction grid that we have to abide by.
So under this new, can you recommend 180 under the sanctions, or do you have to go through a process to get there?
We have the ability to sanction up to 30 days, just like before, but if we exhaust all of our sanction units, the judge could impose 180. Okay. Now, the difference when it was a felony is after they imposed that jail time, and they would stay locally. Nobody for a PCS went to the institution. It was all local jail time. So you didn't serve prison time if you were just on probation for a PCS. Then you would come out with what we call post-prison supervision. So after you serve that time, you get an additional 12 months of supervision by community justice to try to help you continue to be successful. So
there's more resources.
There's the 180, but after 180, it's done. There's not any additional supervision after that period.
Gotcha. Okay. So that could be an area that we have to figure out as a community.
Right.
We also have the ability to bring folks out at any time once they're sentenced to the local supervisory authority during that 180 days. There's some pathways out to where they could go to residential treatment or outpatient treatment. And if they're not successful, we can put them back in custody, providing we have the jail space to allow them to finish that time. But once that time is done, we don't have any jurisdiction over that case anymore.
Yeah, and I think, thinking of where we came from, which was the felony charges years ago, and having that ability to help motivate people into treatment. I think, we've talked before about the lack of willingness to engage with different conditional discharge programs or treatment because people aren't necessarily bothered by having a misdemeanor on their record like they might be a felony.
That's really what we've seen. So
Yeah.
when conditional discharge was on the C felonies, we had a pretty robust program of
Yeah.
people who would enter that because they wanted to avoid a felony.
Yeah.
They might already have misdemeanors on their record, but a felony conviction carries more things with it.
Yeah.
It's much more difficult to get housing and other things when you get a felony conviction. So people would really want to participate, be very motivated to participate in a conditional discharge. And when they became misdemeanors, when we first dropped down from felony to a misdemeanor, we still had the conditional discharge program, and people weren't as interested in it. And so now with the new program, time will tell whether people are going to be interested when it's still a misdemeanor, it's just a U misdemeanor. Are they going to want to engage in the conditional discharge process?
Sure.
But again, if when you're there and you say, I don't want to do the conditional discharge, and the judge says, okay, I'll give you 180 days in jail if you don't want to do treatment, people might be like, oh, wait a minute, I didn't realize that was a possibility, so I will engage. So that's the piece we just don't know. And we know that we don't truly have 180 days to put someone in jail for.
Yeah,
Unfortunately, the defendants know that too.
Right.
So, how much of a deterrent is it going to be if they go, fine, give me 180 days, and then in reality that's 5 or whatever that number is. It's not very long. So that's going to be, again, the other piece. And every community is different. So, the legislature makes this ruling for everybody, this program and this idea. And in a town or a county where they have jail space, this may really work well.
Sure.
And it may work well here. We just don't know. In our experience in the past is that they aren't going to be as interested in conditional discharge when they're just avoiding a misdemeanor conviction. So we'll see.
Yeah, I mean, I'm optimistic in the fact that we can at least address the issues that are in front of us, right? We police officers, sheriff's deputies, state police can look at a situation and say, I need to intervene and make an arrest, and at least kind of remove that problem temporarily, and then provide the opportunities for deflection, and we'll talk about that in a minute, or going to the jail and maybe have an opportunity to get sober and then make a different decision. But it's not this free for all, I think, that we've seen since 110 passed, where you have the public use, drug use, which is offensive to a lot of people, including me, and I'm sure.
Sure.
Yeah,
you and you have kids that are seeing this and things, so those things aren't good. And I think this just by its nature deters it, because there could be that immediate intervention. So that's good. And even if it's not quite the same as a misdemeanor or a C felony, it's still an arrestable offense, and still, for the law enforcement side, I don't think it changes a lot from the enforcement piece. Obviously, we always have to weigh the governmental interest and the level of crime. But I think in this particular thing, the way this was classified is that it's its own unique crime with the U misdemeanor, and not like a C misdemeanor or a B where it's really low level. So that's a decent thing.
The difference between the U misdemeanor and A misdemeanor, I mean, the maximum penalty is the difference, but it's still a misdemeanor conviction.
Sure.
So as far as a motivational tool, I don't know that it would make any difference if it had been an A misdemeanor versus a U misdemeanor. But that's just the piece that we don't know for sure how people will react to that.
Yeah, I mean, I think and I don't know all the ins and outs of those things, but the U misdemeanor means you can put specific things around it, like was done in this case, versus like an A misdemeanor that has a year in jail, or a B that has whatever that may have.
Maximum penalty.
Maximum penalties. And then you can tie the other things around it because it's unclassified, so it's its own unique crime category, so to speak.
Right.
Right.
Yeah. And it'll just be kind of interesting to see, I guess, how it's definitely an improvement over the violation. Because then it was truly a free for all, and we just weren't seeing any real change in people in our community. It was getting worse.
Yeah.
The other piece that's going to be interesting to see as well is there has been an additional funding associated with treatment and withdrawal management beds. So that was part of this, I think, 5204. The funding portion of 4,002.
Right.
Yeah.
And so that is going to hopefully open up some more opportunities for folks to actually go into programming when they're ready. Because when you're ready to go, you need to have the ability to go right away. You can't say, well, we'll get you in 3 weeks because we lose them before that time. Yeah. And so having the treatment available is going to be crucial. Having safe housing for a number of these folks, especially the folks that we see on the street and the Greenway, having the ability to be invested in some of their own life is going to be an important piece. And it's not just the jail, right? But as part of a community justice officer, parole and probation officer, we're engaging people in motivational interviewing. We're trying to set goals. We're looking for ways to get them intrinsically motivated so that we don't have to use the extrinsic motivator of jail. So it's a carrot and stick, but the stick doesn't have to be jail. The stick can be trying to find ways to get them internally to make changes. And sometimes that means a smaller timeout. And sometimes that just means maybe we move into our transition center where, again, it's a bit of a timeout. They're not in custody, but they're in a higher barrier housing option as opposed to, going couch to couch or something like that. So I think all the way around, I mean, people are going to say there's winners and losers in this, but we're better off, I think, than we were 6 months ago. And definitely. I think that we're going to see more opportunities to work together. Even closer, maybe with folks that didn't usually or historically have a chance to partner. So I think if we look at it optimistically, and obviously law enforcement and public safety partners here are working closely together to try to put together a program that is successful. So there's going to be naysayers in everything that we do, but we're going to do the best we can for the livability of the community as we move forward.
Yeah, absolutely. I mean, they talk about like the way the dollars can be spent, or now they're earmarked differently. Before, during 110, everyone thought they were getting treatment. I believe when this was passed, I didn't vote for it, but when it was passed by our Oregon voters, that they thought treatment would be bolstered, which is much needed. I mean, I think we're the 50th of all, we're 50th out of 50 states in treatment availability. And I think with Measure 110, people thought, oh, this is a way to bolster it. Well, it didn't specifically cover treatment. It covered peer services and harm reduction, which is why, which are important pieces, I think, of the whole thing, especially the peer piece has been really effective. But it didn't stand up treatment and in the traditional sense of being able to add capacity. And now these fixes, so there's two bills. They're I think 5402 or 5420.
I don't remember the number.
Yeah. Anyways, and then the 4002, the funding piece, allowed the money to be used differently and expand the treatment piece. So that's good. I mean, I think that's a positive.
Yeah, we definitely need more treatment in our community because, as Kiki said, you've got to get people in when they say they're ready. You've got to be ready to get them in right away. Because you just sometimes have just that short window where you can get somebody. Yeah,
and it also adds parts for education, campaigning and awareness about the dangers of drugs and things of that nature. So it really expanded the use of the overall dollars.
I think the piece that we leave out a lot, and I think it's an oversight, but when 110 went into effect, it impacted juveniles as well. Yeah. So we no longer had a consequence for a juvenile possessing methamphetamine, heroin, fentanyl, you name it. That was also, if you will, legal for our youth, and that's been very damaging, I think, for all of our communities.
Oh yeah, I think Oregon has the highest rate in the country of overdose for youth.
Yeah.
Or one of them. Yeah.
And the message was alcohol, which is, of course, not good for a youth either, but alcohol had a penalty and meth or heroin didn't. The message we were sending to our children was
it was very message.
That was absolutely good. You could get in more trouble for
an MIP alcohol.
Use heroin because it would be
so a 17-year-old who gets caught with drinking a beer by a police officer, and they decide to cite them, they could face potential driver's license suspensions, fines, convicted of a violation. I think that's an A violation, by the way. I think that is, right?
Furnishing alcohol to a minor is a misdemeanor.
just an MIP.
Oh, MIP is a violation. I think
it's an A or B.
Violation. I believe it's an A.
So the highest level of violation, and then if you got caught with the beginning of 110, the very beginning, was 49 fentanyl pills, right? Remember that was the measure before they changed it, like in 22. I think it was 22 it changed. or 23?
23, I think it
23.
was last
You
year.
could have 49 fentanyl pills, and that would be less than having a seatbelt ticket. But if you were 17 and had a beer, you were
A lot more consequences. Yeah.
And that doesn't send good messages, does it?
It doesn't.
Mm-mm.
Yeah, and I think, luckily, officers across the state realize that and probably spent time trying to address the other issues versus the MIPs, alcohols, given the inequities of those two situations
Right.
through the legal
Right.
system. But yeah, kind of crazy.
It is.
So under the new House bill, juveniles would be charged just as
Yep,
the
in
adult.
juvenile court.
In juvenile court, of course. So
yes.
so they wouldn't be mad. Okay, good. So when we talk about sanctions under this, because I think it's fair to talk about jail space. I mean, I have to bring that up as a sheriff, right? And, we have this 180 days now that could be, and like you said, an offender could be like, hey, I'm not going to treatment. Give me my 180 days. I can tell you that we don't have room for that in our jail. So that's going to be kind of a barrier, I would say, for us implementing the intention of this bill to some degree locally. And so I guess for me, I always just tell people, like, it's not the magic bullet, so to speak. It's not going to fix the problem instantly. And then we have our own challenges locally, I think, that are going to further exacerbate any limitations to this, and that's going to be our own locally, which is jail space and, of course, public defenders. And maybe you want to touch on that and understand, like, if somebody gets arrested for a U violation and goes to jail, the officer decides jail is the appropriate avenue for this case, and they go to court the next day, and they can't afford an attorney. How does that process normally work, like that first arraignment?
So when they go to court and they're asked if they want a court-appointed attorney and they ask for one, we don't have any to give them at that moment. So what happens is the court will go ahead and arraign them and set out a court date. Maybe for this type of a crime, it's probably going to be 3 or 4 months, because they know that that's the minimum amount of time it's going to take for them to get a lawyer for that person. So they're going to set the case out for 3 or 4 months. And again, like we talked about before, that interruption kind of stops, because you're not going to stay in jail. You're not going to have anybody to really check in with, likely. And so you're just going to be out there in the community waiting for your next court appearance. We currently have between 700 and 900 people waiting for lawyers, and most of those are the lower level offenses. And so we're not getting enough lawyers to take these cases quickly enough. And so that time is delaying. And we've already had people who have been waiting for a lawyer for more than 6 months. So these folks are going to be kind of at the bottom of that hierarchy, because it's the lowest level of crime. And so when we're going to get lawyers for them is going to be another issue, and it's going to add to the problem, because now we have another crime that we will definitely charge. We are going to have people who are going to get charged with it, and so we're going to add to the problem. Now, if we can get them to do the conditional discharge, then they won't need a court-appointed attorney. So that's an option for people to take without seeking a lawyer to talk to. But a lot of people still want to talk to a lawyer, as is their right, to find out what all the things about their case are. So if they want to talk with a lawyer, it's going to create a backlog. Yeah. And you have to offer that, right? As part of this bill, you'll have to offer the conditional discharge. Maybe you could put that graph up, Aaron. All right. So we have a graph up here. It's titled Oregon Drug Intervention Plan. And it kind of walks us through the intention of 4002 and how it might look, right, from a standpoint of from the beginning contact. And so we'll just walk through this. So, when a police officer is working the street and they get a call for service or make a contact on a traffic stop or whatever it may be, and they find an individual who's in possession of drugs, what was previous an E violation or 110 now is a unclassified misdemeanor, which is an arrestable offense. And so they can do 2 things. Well, actually 3. They can take the individual to jail and say, hey, I'm charging you with a crime, and we're going to the Jackson County Jail, and lodge that individual in. And then they could give a citation in lieu of arrest, which is frequently happens in our county because of jail space anyway. So that's nothing new. But if that's the only thing that they're suspected of doing is the drug charge, maybe a citation is a better use of the deputies or the officer's time and the jail space. They give them a citation.
to appear in court. And then, of course, that would go to the DA's office. Or the third option in this chart, or where we'll be, is deflection. And, we don't have the deflection program set up quite yet, but our hope is to have that or some sort of a program if we're going to do it by the time that we can actually enforce this misdemeanor, which is September of 2024. So, and then in that scenario, the officer, deputy, state trooper makes contact with an individual, gets to talk with them, maybe finds drugs, but thinks treatment might be a better option for everybody involved, the individual, the criminal justice system, the resources we have, and says, are you interested in a deflection program? And if the individual says, yeah, I would like help, they can be referred to, what would be probably a point of contact, whether that's one person, two people, three people, but somebody who would then walk this person through their specific needs and get them into whatever program might be appropriate for that individual. Does that sound? I mean, that's, I think, a pretty good summary. And of course, if they choose not to go deflection and we go criminal justice, they appear for court, providing, they'll get a court date. If they're lodged, they would go to an arraignment, potentially, if they're not forced release due to space. But either way, at some point, they'll have to show up in court, and that's where Beth's office would be taking over.
Yeah, so the deflection cases would never come to our office. So it's only cases that were submitted to us by law enforcement or they were lodged in jail. And then we file those cases, and they would appear in court for arraignment. They would be offered a conditional discharge. Everyone has to be offered a conditional discharge. And so a conditional discharge is a way to avoid a conviction. And so a person could decide to enter the conditional discharge program at that point. They'd be placed on 12 months of probation. They cannot get any jail time at this point, and they would be put on supervised probation with community justice, so they would be connected into treatment. And if they successfully complete that 12 months, then the charges are dismissed and their record ends up getting sealed if they apply for that. If somebody says, I'm not interested in treatment, or more likely it's going to be, well, I failed at this part, so they get a probation violation and we revoke them, then you're going to go kind of to like the next section there where they go to trial and they get convicted at trial. Now they're going to be placed on 18 months probation, still no jail time, still community supervision, connected to treatment, and there's no fines or fees that the court can impose on that case either. And then if they get revoked, then I'll switch over to Kiki and let you talk about what would happen with the probation sanctions and probation revoked.
So if during this period of supervision they have violations, we have the ability to impose a jail sanction of up to 30 days. And then if they continue to not comply or they're engaging in behaviors that we can't support in the community, then we would return to court and request that their probation be revoked, and then they could serve 180 days in jail, with pathways out of that 180 days to go into outpatient treatment or residential treatment. They would be supervised at the level of their risk, and so I think that, again, that's important because that risk kind of guides us on how many times we're going to be having contact with them in the community. And hopefully they're successful and we don't get to the probation violation phase or to the revocation of the 180 days. But once the 180 days is served or credit for time served, then they're no longer within our system.
Yeah. And so when you look at this chart, a lot of avenues to avoid jail and any long-term impacts from being arrested, right?
Yep.
So if somebody gets to the end of this, they're really not interested in making a better or different decision with all the avenues and off-ramps that are here. I mean, essentially, right? I mean, that's how I see it.
Yeah, and that's a long-term investment. We're a few years in. We have 12 months on the conditional discharge, 18 months on the probation, 180 days in jail. If we haven't been able to engage in behavior change at that point, then perhaps they're not intrinsically motivated.
And, you know, we talk about deflection too, you know, having talked with another county who does a deflection, everybody is not for deflection. I mean, that's one thing to realize, that it's not automatic. Violent offenders, people that have history of, you know, potential sex offenses and things that present threats to, you know, community workers, social services and things aren't going to be, you know, eligible for deflection. We're talking about, you know, I think what a lot of people think the drug offenders, the category they fall into is just somebody that's, has a slight addiction issue and runs afoul of the law, and now their life is turned upside down. But that's really who the deflection is kind of geared toward, not the person that's repeatedly violating the community through committing crimes and other things.
Right, or committing serious crimes in the community.
Sure.
That's not going to be the person who
violent crimes
is going
is a no.
to deflection.
Yeah, violent crimes is a no. Sex crimes, generally speaking. I mean, I guess there's certain circumstances, but those things are yet to be determined.
Mm-hmm.
I think the dangers, too, that we're facing here is that we know that when some of these folks go into custody, it's more dangerous for them releasing, especially if they go in with an addiction, as fentanyl. And so, we could see an increase in overdose as people are releasing from custody if we're not doing things while in custody, like continuing MAT or maybe even starting up MAT or MOUD. So that's an issue. But just because somebody goes into custody and they release doesn't mean they stop using drugs. Yeah. And so we might see multiple folks piling up with the same.
Most likely, we will have the same person who
Right.
ends up with 3 or 4 of these charges if they have to sit around and wait for 6 months.
Yeah, I was going to say, from my experience working the road, there's different things that we encounter as law enforcement, right? There's the chronic person who we all know who constantly reoffends, and then there's the kind of the one-offs, right? Like, for instance, driving under the influence at times. A lot of people, all different walks of life, get arrested for DUI in their lifetime, right? Sometimes it's like the one wake-up call, and then it's never again, and they don't maybe need an attorney because, maybe, or they afforded one on their own, and they went through the diversion and done deal, and then we never hear from them again. But it's the concerning ones that we're just kind of talking about that are going to continue to reoffend and reoffend and reoffend and continue to build up charges while they're waiting for the attorney on their first charge and then on their second charge. And eventually some poor attorney will collect all those charges, I'd imagine. Is that kind of how it goes? And then what does that do to the overall capacity of our public defenders when, they could have dealt with somebody up front, on their first charge, and now they have 20 charges.
Right. And the other piece to that, too, is honestly, it won't make sense if the person keeps getting rearrested for the U violation or the U crime. It won't make sense for us to file 6 or 8 of them because you're absolutely allowed under the new system. A conditional discharge must be offered on each of them. So once we can get them past that attorney phase and into the next phase of actually moving forward with their case, either you're going to be now on supervision or you're going to go to trial, we're going to find out what happens with this thing. So it really won't make sense for us to file multiples of these.
Sure.
So we'll have, if we filed 1 or 2 of them, then we probably won't waiting for their lawyer because it just doesn't help us to have 6 of them. Because on 6 cases, you'll get a conditional discharge. So it doesn't do anything. It doesn't increase your criminal history score. It doesn't do anything. So it just won't make sense.
So really the best case scenario, the way you're kind of explaining this is obviously if we had system capacity in all areas, so treatment, jail, public defenders, community justice, is they would go through the system one time and either take, choice A, which would be the treatment piece. They would get resources and maybe never reoffend again, right? That's the hope. Or they would decide to go the criminal justice route, and then we would have the adequate resources to motivate them to go to treatment through the jail piece and community justice piece, or just hold them for 180 days if they so choose to be, that's their path, right? And they're not offending for 180 days while they're in custody. So there's a relief to the community. But when we don't have adequate treatment, jail, or public defenders, those paths won't be clear cut, will they?
No. Nope.
Well, let's talk about the deflection piece. I think Kiki talked a little bit about us having meetings, and we're all trying to figure out where can we alleviate some, burden on the jail piece in the criminal justice system through deflection. So what is the deflection piece? And whoever wants to.
So the idea behind deflection, and it's up here on your graph, it's the first little box. So the idea, every community doesn't have to have a deflection program. Some will choose to have it and some will choose not to have it. we were included in one of the first 23 counties that has some money kind of earmarked for us. So if we choose to go forward with it, then we're going to have some money to work on this program. And so what deflection is really meant to be, and it can be different in every community, is a law enforcement officer, when they have that contact with you out on the street and they sense from you or talk with you and figure out you're interested in treatment, you're interested in stopping what you're doing and getting some help, right there on that spot, they would have a way, in an ideal situation, they would have a way to hand you off to an actual treatment person, a peer person who's been through this and can talk them through it. But they would have a way to hand you off to someone else who would then engage you in treatment, engage you in whatever services the program has to make it so that you won't continue to have criminal behavior. So, I mean, that's the kind of the ideal way it's meant to work.
Yeah.
You know, some counties that have it currently, they have a housing piece to it. And again, we don't know what our program's going to look like yet. So is our program going to have a housing piece to it? So where we had talked about like the jail is the stick to kind of make people do things, you know, well, what are the carrots? What are the things that make someone say, I've heard about this deflection thing and I really want to do it? And if it's some housing assistance, which is an important piece for a lot of people in this position.
Especially the overall recovery. That
absolutely could be really important. Getting them quickly into treatment would be another thing that this deflection program would have. So it's an interesting concept, one that, you know, we have never done in Jackson County, but that we have some interest in how where are our shortfalls in our county? So where could we have our services? What can we offer to people? What are going to be our carrots to offer to someone to encourage them to be in this program? And if they say, oh yeah, I want to do that, but then within a day or two or three or a week or whatever the time limit we set, they don't follow through, then we haven't lost anything with them. They can still have the case referred to my office. We can still file it.
Sure.
And so it's kind of an interesting idea. And I think, again, it's really going to depend on what we can offer people and how we can bring those services quickly together. And for example, when we set up mental health court, we did it without any grants in Jackson County. We just were like, people who were doing the work, my office, parole and probation, the court, public defenders, we all just came together and said, we got to do something better for these people with mental illness. And we set up mental health court, which is now called wellness court. And it made a substantial impact on folks, people who were constantly being arrested, people who were, just constantly in the hospital or having all kinds of issues in the community. And we really saw a lot of people succeed at that and do really well with it. So, I think deflection has some of that same kind of hope to it if we can just find the right services and we can identify the right people to offer it to.
Sure. Yeah. Yeah, I really see from like a law enforcement standpoint and being the kind of the gateway of the deflection program is, people who are working the street, they'll encounter somebody. Maybe their overall demeanor is cooperative, but they're found to be in possession of drugs. And then they talk to them about deflection and they say, yeah, that sounds really interesting. I don't have a house, I don't have resources, and yeah, I'm down on my luck and I have a drug problem, but I'll go. That's where I see this being effective, not where, we have burglars who are caught with possession and people who are constantly committing crimes. And I say that just for the public's understanding that I don't think the officers, it'll really be their discretion based on the circumstances and the totality. And I see in our county, we've talked about a small test group first, that's something that we can manage overall, because if all the law enforcement at once started calling or trying to use deflection, we just wouldn't have capacity, I don't think, right? With how busy it is here. There's a lot of drugs in Jackson County, unfortunately. But I do think, I think there's going to be room to see how this works. And I think there'll be specific cases where it can be successful and alleviate some of the strain on the jail and overall criminal justice system. But I really like the aspect, if that's not working, we can go back to using the criminal justice system to some degree.
Go back to our traditional ways of dealing with that person.
Yeah. And, you've been supervising people for 33 years. Is that what it was? 33? Yeah. And so you have a pretty good insight on some of the mentality of offenders or people who are convicted of crimes. What do you see with, typical, like, say, people who are chronic offenders, especially with regards to drug charges and, say, crimes associated, property crimes, low-level misdemeanors that are, I would say, definitely a part of their addiction.
And I think it's important to kind of distinguish between the two a little bit, because you have those that are addicted that continue to commit crimes, and then you just have people that are criminal.
Sure.
Right? And sometimes there's a blend of that, but not always. Sometimes people are the people that are dealing that are actually engaging in the criminal behavior.
Sure.
I think overall, if we can first address some of their basic needs, the social determinants of health as we move forward, housing is a big deal, just getting their basic needs met, and then moving into trying to engage them in treatment. And not everybody that engages or that has an addiction problem and has motivation is ready to go into treatment. Sure. And so I think that's where our peers come alongside them, which is a fairly new concept, I think, in Oregon. Maybe over the last 8 or 10 years, we've started really focusing on peers. But not everybody is ready to go right into an outpatient or residential program. We have to get them ready to do that. And so I think between engaging in some of those strategies that shift their thinking, but also pairing them alongside somebody that's already walked through that process is important.
Sure.
So I think that's a hole that maybe 10 years ago, we a gap that we just didn't understand how to fill. And I think we have a lot of great peer groups now that can help with that. But it's important, too, to make sure that, and we've talked about this a little bit, but we have to have the ability to interrupt criminality and interrupt addiction.
Sure.
And criminality interruption might result in somebody going to the institution because they deserve to go to the institution.
You say prison.
Prison, right? Oops.
Yeah.
You can...
The big jail.
You can leave that part out, Aaron. Yeah. So there's definitely folks that need to go to the institution, and that's criminality. There's people that have addiction that engage in some sorts of criminality that maybe we can address their criminality locally and with appropriate things in place, services in place. There's a big willingness in this community to want to be part of something. We're launching another program through the jail, and it's amazing how many people and organizations are interested in actually working with our population now. 10 years ago, we couldn't get people in treatment because they didn't show up. They were difficult to deal with. Mm-hmm. They came with a lot of baggage, and I think now we're really starting to see a change and a shift in those folks that are willing to work with our population. So I'm excited about that opportunity as we move forward. No,
we've seen that. We have a lot of willingness of people that want to come into our jail. And I think part of that is, just we've done things with our jail, I think, to shed light on the inadequacies of jail space, that we've opened it up and people see what it's about and concur, like, there's space issues and there's other things and there's better ways to do business than just, locking people up and throwing away the key.
Tail and nail them and jail them. We don't do that anymore.
Yeah. Mm-hmm. So, I think there's definitely a more progressive approach to, like, looking at all the issues instead of just the criminal justice piece and seeing how we can braid services together. I think that's smart. I think we have to do that. Right. And I think, the addiction side of things, treatment and all those things, won't be successful without the criminal justice system. And when I say that, I mean people who are committing crimes who are addicted to, right? Not just somebody who has an addiction issue, because that's never what I talk about, because it never crosses into my world. And we probably won't have good success without their partnership. And I know people like to push those apart all the time, especially people who don't work in either field, right? Because I think what we're seeing now is I've had a lot of support, for our sheriff's office and for jail and for other things to work together, right, to address the problem as a team, like you're saying, versus, no, we're not talking to them and they're not talking to us, right? I think.
Right. Well, that's where the success will be.
Yeah.
Is if we can work together on those kinds of things and have a kind of a handoff sometimes between the jail and treatment or the jail and probation. So again, we don't lose people.
Yeah.
You've made changes on even like what time you release people.
Yeah.
And that made a big difference.
Sure.
If you're releasing someone in the middle of the night, what are they going to go do? Probably go break into a car or a building or something because where are they going to stay? That kind of thing.
So go back to the flop house they got arrested out of. Yeah. Now, speaking of institution, I can't say that word when we talk about prisons. I know maybe, but how many people in your career, because you've been the DA for
36 years.
Been in 36 years.
36, the DA for 12.
DA for 12. I think there's a misinformation out there or this assumption that people go to prison because they get arrested for having low-level amounts of drugs possession. But I've heard it. Like I listened to the legislature testify about all the bad things and how people across the country, and I can't speak for other places, are in jail because of minor drug offenses. And it's like, that's not necessarily the case. In fact,
we got sentencing guidelines in 1995, and so since 1995, no one has gone to prison on a possession of controlled substance case. It's impossible for us to get them there unless they went with another charge or something. So like, I just want to be really clear about this. So, since 1995, if I were to be arrested every day for having a residue bag or, whatever, a pipe or whatever. Never get you to prison.
I could never go to prison for that?
Never.
Nope.
Every day I could get arrested.
Every day. Yep. It doesn't, because it doesn't have the capacity to send that person to prison. The only sanction we can use is county jail.
So, the idea that some people, especially I think opponents of changing 110 used about prisons and this and being full is just nonsense.
Not true in Oregon.
Not true in Oregon.
No.
Yeah. And I'm going to speak for other places. I don't know how they work.
Right.
I mean, I'm assuming like other places like on the West Coast don't do that either. But I've just never really heard of a low-level drug offender going to prison. It's usually going to be repeat property offenders who also have a PCS or a violent crime where they were found in possession of drugs too, and they've lumped it together. But there's the underlying crimes that got them into prison or the institution is the violent offense or the repeated community violations, the burglaries, the thefts.
Criminality got them to prison.
Yeah.
Not
that's the
addiction.
crime that could get you the sentence where you could get sentenced to prison.
Yeah. So, okay.
And it takes a lot. You have to earn your way really to prison anymore. I mean, it takes a lot to send somebody to the institution. And not that that's any type of goal, but we certainly need to have the ability to send those folks that deserve to go.
Well, and I, always applaud the efforts of our community justice, because we of the GRA funding, which is Justice Reinvestment programs. So we get money basically to think of things to do other than just send people to prison. Right. And I'm more of a law and order guy on the sheriff's side, but I certainly see the value in that too. But we do a lot of things, I think, that are creative here. And we don't just send people to prison. I mean, in our last round of funding, there were some hoops that we had to jump through as a county that you had to jump through specifically, but it had help just to keep funding for the programs that we had set up because they believed, we were using prison, which I think we were using it higher. But when you looked at the cases, it was like, yeah, we have to use prison at some point. Is that?
Yeah, that's accurate. And it really was a team effort. Each person at this table had a lot of influence in helping us get through that. But they're judging us on what our prison rates were in 2013. And so that's an old snapshot of the way that we used to do things. And so one of the things that we've asked the Criminal Justice Commission is to change our baseline. And so I'm hoping to see that come out in the next, I would hope 2 years. I don't know if that's actually something that's going to happen, but there is a lot of effort and cooperation amongst agencies to provide people the opportunity to be successful in the community. And a lot of those are called downward departures, where if they're not successful and we've continued to try to engage them locally in services, if we're just not able to get there, then we would go back to court and alongside the district attorney's office and recommend a revocation for that person. Maybe they need a longer timeout. Maybe they're engaging in more criminality that we don't have the ability to do anything with. So, but we do work very hard as a team to try to send the right people to prison at the right time for the right reasons. And that's, as we move forward, the way that we should address all of this, all of our public safety system. And I think we have the right people at the table, and we are all doing it for the right reasons, which is we want to contribute to the livability of our community. Yeah.
Well, one thing I'm really hoping for with the changes that have come and that will come along the lines with House Bill 4002 is we've seen kind of a spike in violent crime since 110 came in our county. We've seen a lot of Measure 11 arrests come into our jail that it's substantially higher than it was pre-Measure 110. And then those things, obviously take more resources for your office when you have to, prosecute them and then, see those through to trial because they're often in jail for a long time. There's a lot of work that needs to be done. And I don't know if we need to go into all that, but it takes your resources more so.
Yes.
And then, of course, the public defender's resources are used.
Right.
And when we have a pretty high rate, I think we had the highest, well, we certainly have the highest per capita, I think, in the state of Oregon, Measure 11 arrests, which is unfortunate. But I saw a huge spike post Measure 110. We also had some jail closures because of the pandemic, which certainly affected those numbers because we lost jail space. And I think there's a real correlation to jail space, not addressing people at the low level, keep kicking them out, and then they continually offend until they do something more drastic. And it seems to be, crime always seems to be an evolution. I mean, not always, but a good portion of the time it starts off with low-level offenses and then escalates at times. Now, yes, we have the one-offs, domestics, and some other things that do go from no history to murder. But but a lot of times with the offenders that that are they're going to be involved in the system, or that we call the chronic offenders, there's an evolution to their crimes, and that's unfortunate. And with the drug 110, we saw like a lot of our violent crimes were associated with drugs, either under the influence or still surrounding distribution of drugs. We had some homicide cases, around the marijuana grows and other things. So, yeah, certainly I don't think, I think your numbers might have changed because you weren't supervising the low-level drug offenders, so less people on probation maybe, but were the offenses different that you were supervising? Or
we were at around 2,800 prior to ballot measure 110 reform, and then we dropped down to about 1,750. We're starting to see that number pick back up. So it's a fairly large population of folks that we lost. And you have both heard me say this before, but the risk level of the people that are coming onto supervision is the second highest risk level in the state. We are a very high risk population. We have 107 less high risk offenders than Multnomah County. And they have almost triple our population as far as a supervised population. So that's significant. Is it directly related to drugs? Probably, because when you start looking at what risk scores are, it's based on arrest and criminal history and a number of failures to appear. And there's a whole list of things that end up making somebody a high-risk person. But one thing I wanted to touch on, we did some research, and Sheriff, I know you know about this, when we started taking a look at the number of people that we were sending to the institution, and we found that from the first arrest until adjudication, when people were forced released from jail, they had up to 4 additional events in custody. And that's significant. So as you were saying, it piles up. It does, and we have the data to back that if at the first arrest we could have maybe
got him into supervision
and services and treatment, then maybe we wouldn't have had those additional 4 events that resulted in probably increasing their risk score, as well as the sentencing guidelines grid, because the guidelines grid, each time you get a conviction up to a certain amount, increases their risk history. Yeah,
and we've had a high risk or a high number for high risk offenders. Sounds kind of weird.
It does.
Yeah,
it does.
We've had a lot of them, compared to other counties for a long time. And I'm a firm believer that lack of jail space is contributing to that because of our inability to address low-level offenses. And so they don't really get the attention until we sort of saying, okay, everybody is being impacted by this person, the system, and everything else. And that's a sad thing to say, but that's the reality of no jail space, which I think further exacerbates the public defender issue because there's more charges, and then so on and so forth. And then, of course, your community justice, your high-risk offenders are basically created out of the lack of our ability to address them early and frequently. And then, of course, then there's the entitlement piece, and it's just a kind of a mess.
Yeah,
really
and
is.
Another factor I think is how the drugs and just kind of the free-for-all that we've had with drugs under Measure 110 has exasperates mental illness. And then we also have the shortage of the state hospital resources. And so, it's like every part of the system is, at the maximum capacity and about to break, basically. So that's another piece. And sometimes those violent offenses are due to mental illness or exasperated by drug use and mental illness. And so, sometimes they stay in custody long enough that the mental illness clears. So it really wasn't the mental illness, it was the drugs.
Yeah.
But sometimes we're not seeing it clear anymore like we used to with folks. And so then, we have somebody who's committed a very serious crime who is maybe not going to ever be able to go through the process, go through the system, because they can't aid and assist in their own defense. And so, that's like another piece, but I think Measure 110, added to that because of the drug use and there was that no interruption to the issues. So when you would see someone who was out on the street who clearly had mental illness, maybe it's not a danger to themselves or to others at that moment, so you can't take them into custody. You can't do a mental health hold on them. But you couldn't interrupt it with the drug usage either. And so then there was just like that compounding effect.
You have to wait until they do something so egregious to where we have a victim, potentially, and lives are ruined on both sides.
Exactly.
Yeah.
Exactly.
That seems like a pretty poor way to do business. And again, I know talking to the choir here,
exactly.
as far as if we approved of 110 or not when it was passed, but the voters, that's what they chose, and I think, again, misled a little bit. But certainly I'm glad for 4002. I think we can start clawing our way back. I think it's going to take a long time. I remember, were you guys at the forum that the charter put on with the panel of, there was a peer support and there was addictions?
I think so. I think I was at that.
At the country club. Mm-hmm. Anyways, Bob Wise was great guy, but he asked one of them a question about how long it would take to fix, because I said it would take longer, and he quoted me. The sheriff said it's going to take more than 3 years to fix this problem, which I stand behind 100%.
Absolutely. Yeah, absolutely.
And I think about the impacts of 110 overall. One, we have to put all this stuff back together. We're probably going to have to revisit the legislature and say some of these things are working within this bill and some aren't at some point, and say we need this too, or we need to get rid of this, or whatever. I think that's normal when you start changing laws and going into territory that's frankly never been gone into, I don't think. Especially 110, we're the first state to ever try this, by the way. Right. But putting everything back together and addressing the host of issues that was caused by this experiment, and I'll call it an experiment. But then also, when you look at why do people use drugs in the first place? And there's a lot of thought into why that happens. But, trauma is a big one, right? People self-medicating, not having the resources to deal with underlying issues, whether they were abused as children or experienced other traumas in their life that they're trying to now basically get away from by drug use. Well, how many people have we exposed to trauma through this experiment? Kids who've watched parents and loved ones die of overdoses, experienced abuse at the hands of people who are using drugs.
Neglect.
Neglect,
increase in neglect.
Significant, yeah. And we're seeing kids exposed to drugs. I know the Children's Advocacy Center started doing some testing and found pretty high rates. And I don't have those in front of me of kids that were exposed to drugs, hard drugs, marijuana and hard drugs. And so, what have we done for the next 10 years or the next 15 years that we're going to be dealing with in the criminal justice system? It's kind of frightening, actually.
It is. It is.
And that's never really talked about as a consequence of.
And in 10 or 15 years, when we see those cases coming up, because those people have finally aged into the criminal justice system, will we really associate it back to this, or will we associate it to other things too?
Well, if I'm still around, I'll talk about it, and I'll remind everybody. I mean, I don't know, be the sheriff in 15 or 20 years, but I'll certainly do my part to make people aware.
Yeah. One thing that Kiki touched on earlier that we haven't talked about is medically assisted treatment in the facility, MAT. So maybe you can talk a little bit about that, because House Bill 4002 had some earmarked money for that as well.
So there was a couple things going on. So prior to a lot of the talk, I think, in the legislature about revamping 110 completely, there was, I think, some patchwork that was being worked on. And, with good intention, of course, how do we address some of the issues before there was a lot of appetite to just do a full court press. And one of the things was a bill that our office and a couple other sheriff's offices were working on across the state, and Pam Marsh helped with sponsor the bill, was money for MAT treatment in jails. And that's a huge thing, I believe, a huge place for us to start MAT, because when you think about what that means is somebody comes to jail, we're able to hold on to them for a while, and then once they get into a place where they can make a decision, which takes a couple days usually, at least. I mean, I think to be clear, it takes a way longer. But, we had Dr. Mann who talked about some of that in our last episode about time frames and intervention. But certainly MAT, can be a huge, I think, benefit to the individual and then to the community, because if they go out, say sober and under medication, especially depending on what medication it is, there's opportunities for like 28 days that they're not wanting to use drugs or can't get high. So those kinds of programs can really buy a month of this individual being able to make better decisions. And there's money within the short session to implement some of those programs. And of course, we have some other dollars or some opioid settlement dollars in Jackson County. So we've been working on that with Stacy Brubaker, who's in charge of our Health and Human Services, to stand up a program. So we don't know if we're going to even ask for dollars, because we might have some set aside. But counties that weren't part of that settlement, especially in rural counties, there's money set aside. So jails that typically don't have resources or have smaller budgets can stand up MAT programs within their jail. And I think that's a significant game changer for people, especially when you talk about like the fentanyl and opioids.
Right.
And I think that program, coupled with our Justice Reinvestment Program, which we're starting, where we're going to have folks in the jail that are going to be helping with safe pathways out for people. Because even once you release, you still need to have continuing follow-up and care when you're on MAT or MOUD. And so sort of making sure that we're tracking them to get them integrated into community care is going to be really important.
Definitely.
Yeah. So I think going through this, like to wrap this up and just kind of surmise it. But so, jail's an option. It's at the discretion of an officer whether or not they say, hey, do you want deflection, or do you want, or we're just going to take you to jail. But then once they get to the court piece, let's say jail's offered, then there's a conditional discharge avenue, which is another off-ramp from just straight.
Right, avoid a conviction.
And then, of course, then there's
you revoke the conditional discharge, and now you're just on probation.
And then, of course, there's a lot of avenues. And then there's automatic expungements of records upon completion of certain things. And then there's automatic, even if they just...
Yeah, all of these have an expungement component to them. That was very important to the legislature.
Yeah.
So even if the judge gives you that 180 days, you can expunge it within 3 years. All of these are set up to not... affect the person long term. The conviction just affect the person long term.
Yeah, and I think I think that particular reason for some of this has been overused, but I do see cases where, like if you had a drug offense and it was a felony back and you were a convicted felon because you got caught one time with cocaine,
right, and
you were not otherwise you didn't commit crime. Just that was it.
It's only one.
And now you have a felony conviction, and now you have, and I can see the real now are we going to make this person's life much more difficult because of a one-off or a small decision that was made on a weekend, right? So I do agree with some of these. I think it's going to cause us some additional work with all these expungements, and that could be that's going to be something we're going to have to absorb within our current FTL course. We might be able to apply for some funding through some of the dollars that are available because the treatment piece and the education, there's also dollars for other programs. And if expungement's piece of that, there might be some availability for money for sheriff's office or for one of the local PDs to take on that program.
And a lot of these had expungement before, but now the legislature has put tighter deadlines on it. So now you have to get it done within 90 days. Yeah. We didn't have that before. So that's going to be the crunch for the court, for law enforcement, for my office, that getting things sealed up within that amount of time is going to be the crunch.
Well, and it's not automatic.
Yeah.
I mean,
they still have to apply.
And there's a lot of work involved. I mean, automatic makes one.
Although they say automatic on the graph, but it's not. It doesn't just happen. You still have to go through a process.
Yeah, but it was, I guess, insinuated that it would occur.
But you can get it. It's not optional in that sense. You get it, but.
It leads you to think, though, that it just happens without all of this extra work. I mean, we see it in the juvenile side, too, you know.
Like
automatic
there's a computer program
really,
that just automatically deletes everything at day 180 or whatever, 3 years, right?
Yeah.
Yeah.
So there's an expense associated with that.
Oh, that's what I mean. It's going to be could be a significant workload for like my office or, you know, MPD or your office.
We already have a lot of expungements pending. So this could have that many more added.
Which is positive.
Yeah.
But it does just show that nothing is without cost.
Yeah, definitely. Well, let's just hope. My hope is that the reduction in some of the criminal activity, the improvement in livability for our community, and, you know, maybe the I don't know if that's going to be the right word, because I think we're going to see an increase in arrests at first,
right,
and an increase in workload at first, but maybe the overall harm to the community is less, if that makes sense. Less violent crime, less livability issues, less open air drug use, less things that people are exposed to long term because of this, even if it changes our workflows. I mean, because either way we're dealing with the work, right? Like if we're doing a bunch of Measure 11s, versus PCS cases, you know, the deputy's time, the officer's time, the DA's time, your time, everyone's time is less dealing with a PCS case than a Measure 11. So, you know, we might have more of them, but, you know,
I think
we don't have victims on both ends.
I think you bring up a good point. The county's health assessment, and I'm not saying that correctly, but it just came out, and the number one factor that people in the community were concerned about was their public safety.
Yeah.
That's the first time public safety has been at the top of the list. And so...
Well, I'm doing my part. I as you know, I really I'm going to be, you know, stumping for a new correctional facility, increased jail beds, and for a lot of reasons, you know. But one important one is like we got to do something for our community.
Yes, absolutely.
Agree.
So, all right, well, thank you for being here today. I really appreciate your time and your expertise. And hopefully we've provided a lot of good information for our public to consume and hopefully better understand the changes that were brought to 110, and then understand the limitations that we might have, and don't have expectations for like flipping the switch and everything is better tomorrow. So thank you for your time.
Thanks, Sheriff. I appreciate you having this program, because I think it's really important for people to understand better. And we've provided a lot of information. It'll be a lot for people to digest, but it really gives them a better overview of where we think we're headed and where we hope this will get us.
Yeah. I agree. I appreciate the opportunity. And I, again, just want to stress that it's important, I think, for the public to know that it's just not one agency working on this or one person. We are collectively working together to try to do the best we can to implement this, and it's definitely going to take us some time. I always talk about, and I know Beth that talks about, and you, I think I've heard it, but the relationships here and the efforts to work together to do things to benefit the public is pretty strong, especially when you look at other places. Yeah. We work together pretty well, and I think that's a benefit, and hopefully we'll be able to get a handle on this and do the best with what we have. So. Yep. All right. Thank you.
Thank you.